Hi, I'm Ray Littleton, an attorney at Foster Swift Collins and Smith, and today we're going to talk about hiring and firing employees in an at-will employment world. Now, as many as you might know, an at-will relationship is one in which the employee and the employer may terminate it at any time for almost any reason. There are exceptions to this at-will employment relationship, and we're going to talk about a few of those today. One of the first exceptions is the Michigan public policy exception. This exception applies where an employee refuses to violate a law in the course of their employment, or the employee is exercising a right conferred by the Michigan legislature, or there is a violation of law specifically prohibiting an adverse action against employees who engage in certain protected activities. Another exception applies where an employer gives a clear and unequivocal oral promise for a just cause employment relationship. Now, a just cause relationship is one in which the employer needs a cause for the termination. That means that they cannot fire the employee for any reason at any time. Here they need a strong cause and a strong reason for the termination. Another exception is the legitimate expectation exception. Now, this exception applies through a two-step process. First, the courts will look at if anything the employer has expressly or impliedly promised to the employees. And second, they'll look at they must determine whether the promise reasonably is capable of instilling a legitimate expectation of a just cause employment relationship in the employer's employees. So, what has the employer promised or provided that legitimately expresses a just cause employment relationship and instills that in the employee? And those are the things the courts will look at under that exception. Now, one more exception to the at-will employment relationship is where the employment contract provides for a definite term. And by this, I mean that the employment contract provides that an employee will work for the employer for a specific period of time. Now, with these relationships, the Michigan law automatically implies that these relationships are for-cause relationships as opposed to at-will relationships, meaning that employers need that reason to terminate the employee and can't do it at any time for any reason like an at-will relationship. Now, employers should frequently consult with their counsel to best protect themselves before making an employment relations decision or when they need consultation regarding a wrongful termination claim or potential claim. If you have any questions, please feel free to contact me. My phone and email are on the next screen. Thank you.